and then all co-authors will take questions and comments. We will alternate questions and comments between the audience in the room and online. To the audience in the room, when you speak, please switch on your microphone so that the camera in the center of the room turns toward you. To those attending online, please keep your microphones muted, but the video switched on if possible. During Q&A, you can use the hand function if you want to ask questions or to make a comment. Thank you all for being with us today, and especially to our speakers. Claudio, please, the floor is yours.
Okay, thank you, Daniele, and thank you to the colleagues at the Robert Schuman Center. I'm speaking with a normal tone of voice. If this is not okay, just let me know. Otherwise, just want to thank you for coming today. I see we have more than 20 people, which is a good turnout for our standards for a technical paper. I will present this paper authored with Jonathan Kamkaji, Gaia Tafoni, and Claire Dunlop. Although in presence today, we have Gaia Tafoni and Claudio Rodelli from the other side. I will use slides. If there is something you need to ask me during the presentation, please do it. Okay, so let's see. It's looking relatively good. That's the title of our paper. It's a little bit there's a bit of suspense because we don't know what the pieces are that do not fall into place, but we see that when we come to the empirics, and that's the way we frame the paper, leaving it uncertain in the first part what the pieces are. I see people are coming in, and I'm now co-host, so I'll let them in directly. Okay, so what are we doing here? We are working in this project called Procedural Tools for Effective Governance, Protego, and let's say that our topic is the design of regulatory procedures in the EU 28, so the EU plus the UK. Obviously, when you have some regulatory procedures, regulatory policy instruments, there are many different ways to think about cross-country variations. And those are, to say now what will be explained later in my presentation, the different, obviously, theories about regulation, about the European Union, about policy design, about isomorphism. So you can go on, and all of these theories pretend that they put the pieces into place. We have embraced in this project a particular framework, which is in itself part of what Elinor Ostrom did with the institutional analysis and development framework. And within that framework, there is the so-called grammar of institutions, also known by the acronym IGT, Institutional Grammar Tool. I say a few words in a minute on the tool. I'll move Claudio here with the horse. Okay, so in order not to put the horse behind the proverbial cart, we started with this approach. We have 4 regulatory procedures that are not the only ones, but they're pretty important in defining the moment of rulemaking. I use rulemaking in the North American sense of including making regulations, but because we are looking at the EU is also making primary legislation, and I will clarify in a moment. But we're looking at consultation on the impact on at the moment of creating a primary or secondary legislation, so rules and laws, impact assessment again of primary and secondary legislation, Freedom of Information Act, and more broadly, access to regulators and government departments, again, during the process of making legislation or regulation. And finally, the Ombudsman as someone who can question the procedure on the basis of maladministration. So essentially, we took the process of making rules, and we asked the questions, what this is. These procedures, obviously, they do two things. They impose obligations on government departments and regulators, as well as enfranchising some specific interests. We decided to look at these procedures in terms of what they have in common. There are many indicators produced by researchers, by the OECD, by the World Bank, then instead look at the procedures one by one. They open the box and look at what is inside. Because we are social scientists and not international organizations, we are more interested in the analytic properties that can travel across these procedures. And as I say in the slide, we try to identify a single template for the measurement of the four. Then we look at the evidence and we interpret the evidence, and then we see what pieces fall into place according to what theories or not. So that's the approach we have chosen for this paper, which is one of the papers in the project. There are three problems before we do that. One we already sketched, it is this one of measurement. One is the concept formation. What is it that we're measuring here? And the third is comparison across 28 countries for instruments. How we do that? Well, see if I can make it a tiny bit bigger on my screen. Sorry about that. This cloud is a bit invasive. We look at the policy instruments that revolves around a set of rules. The intuition is very simple, is to see, like with my eyes, I see these instruments as if they were made up on a given set of rules. Together, all of the four instruments define something that is a rulemaking action situation. That's a term we borrow from Elinor Ostrom. The rules define what goes on in a constellation of actors bound by institutional statements. So we are in the family of actor-centered institutionalism. So if rulemaking is the macro action situation, then consultation, impact assessment, ombudsman, freedom of information are the procedures that define more specific nested action situations. Put very simply, there are rules for each of these four procedures, but the beauty of the approach devised by Ostrom that we borrow for this paper, and Sue Crawford and others, but let's say the beauty is that we have a small number of rules that we can use to read and X-ray all the instruments that we have in our project. So we solve the measurement problem with a theoretical approach that is not idiosyncratic. It does not look at what is inside consultation or the property of impact assessment, but rather asks the question, what are the rules that define the interaction amongst the actors and the relationship between actors and the institutional environment in which they operate. And those are what, according to this approach, the rules that define the design of a procedure. They are the same across the four procedures. Adrienne and a couple of others who came to another presentation that they've seen this slide already, but essentially this is what are these rules? They're very intuitive, very classic, I would say, of actor-centered institutionalism. Position rules, the actors, let's say, the boundaries of the actors, what the actors can do, choice, when they have to come together to take a decision, aggregation, so decision-making, information rules, how do they exchange information in the system or in the action situation, the payoffs, cost and benefits of doing something that is prescribed or not doing that. And finally, the aims, the identification of what is required, desired as an outcome of the action situation. Here we have 7 rule types that allows us to then open the box of consultation or impact assessment or Freedom of Information Acts and see what's inside the box independently of the specific characteristics of the instrument. So each instrument is like the others in terms of the 7 rules, and what matters is the variability, the density, the intensity of the rules in a given instrument. Then we have to interpret. Okay, yes, okay. So our research questions in this paper are very natural for comparative politics and comparative public policy. Comparing the rule types, we can read the 4 procedures through the rule types and see how they differ, whether they pick in some type of rules or not. This is descriptive research question, but gives it the advantage of examining the instruments by rule type. Secondly, how do we best explain variation in this population? And then we try then, since we found, I forgot the number, 265 rules categorized in the 7 types, there must be something that is in the structure of these rules that best explain variation. Classic question of comparative politics that can be dealt with latent trait analysis or principal component analysis, which is our choice in this case. Yeah, so you can see me now. And then having identified the components, that's more interesting for those who obviously they want to compare countries in terms of Europeanization, ways of exception to the EU, or maybe carbon copying regulatory procedures from the OECD as the variation across countries. Okay, let's get into the data creation and collection. We did not use a survey, but we created a network of relatively young academic lawyers in the field that were trained and supervised by us. And these people, very helpful, they work on protocols for data collection. There were no surveys. We were saying, you are an expert on Freedom of Information Act in Croatia. What does the law say about the 7 rules? Obviously, we rephrased, we didn't say, find me the scope rules. We said, what are the outcomes that are prescribed, allowed, or prohibited by the legislative procedure or guidance book of the government? And the lawyer will say, it's all in Article 22 of the procedure or page 21 of the guidelines. I say, okay, what is this page 21? Give it to us. So we just coded, there are millions of people are doing law as text. We did it in this way, which is qualitative and very hands-on from our side. We work with these lawyers for several months. And we have some faith in the reliability of this data. So this is just descriptive. I'm not spending time on this, but obviously that's a table that shows what these position, boundary, choice rules look like in terms of our procedures. If you don't, position is the actor, so typically departments, regulators, and then we have these procedures like freedom of information, where we have 3 positions: who can request, who must answer the question, and whether there is a dedicated appeal body. And then again, boundaries, choice, aggregation, payoff. Those are just exemplars of what the rules are. Let's be a tiny bit more analytical. We can look, I move myself here so you can read the table. We can look at now at the rule types by instrument. And I don't know if you can see all the table. I don't see the 4th line, but maybe it's my screen. I want to show you this, that already we see that these procedures typically don't have aggregation and information and payoff rules. There are very few of these rules, meaning that the structure of incentives is not particularly strong, because if actors do not behave according to the procedure, there are no sanctions. Neither are there many incentives. And that tells a lot of how these procedures are designed, especially RIA and consultation. We also see that those procedures are very dry. They don't describe their aims in many words, except for consultation, which is the more, let's say, literary type of procedure, where governments state the purposes, aims of consultation. All this data come from nationwide procedures. We also looked at regional and sector variation, but the data were collected in a less granular form, and they're not portrayed in this table. So we are looking at consultation as whole government process, although in many countries there are consultation rules for the telecoms, for energy, and for other utilities. So those are really country profiles. When we look at the variables that explain more the variation in our population, which is EU 28 plus UK, as I said, here we are presenting the data as coded on the procedure 2018. We also asked how many times was the procedure changed, and we have data on the longevity of the procedure. It does not appear in this analysis, so time is not portrayed in this analysis. With this caveat, let's look at consultation. I just said a consultation has scope rules, aims, and we just portray here the first two components that together explain more than half of the variance. One is the commitment, and the other is a scope, which is, as I said, avoid discrimination, plain language, etc. And you can say that all the variables we coded in the third column are mirrored by a type of rule. Oops. Okay. Impact assessment of proposed legislation. Here, the principal component analysis extracts, we need to look at 3 components before we reach 50%. Obviously, there are as many components as one wish, but they explain fewer and fewer percentages of the variance. The first is about the exceptions, so the boundaries of the procedure. So you can see the 4 boundary rules nicely clustered together in the principal component 1. The second is a bit the core of impact assessment and our requirements, especially the important one of commensurating the expected benefit and costs of proposed legislation. And we have 2 choice rules that together explain 15% of the variance. And then we have 2 rules that together define the publicity of the instrument. So this instrument is analytical and is also a communication tool. It goes often together with the explanatory memorandum of proposed legislation. And the third variable component, is about the publicity of the analysis done in impact assessment and of impact assessment as document. The third component, the 3 components, I move myself somewhere else, of the Freedom of Information Act are, again, nicely clustered, especially 2 and 3 are all boundary rules. Obviously, the first question about Freedom of Information Act is when is it not used? The so-called harm tests, they all together in the second component. And the first one is about the design of the Information Commissioner as institution, as body, the presence, the power, the paperwork. And we have as a third component, more tests that discriminate acceptable or unacceptable requests in terms of national security, competitiveness, and personal information. So those are boundary rules that demarcate the activity of the information commissioner. For the Ombudsman, the first component we extract is a combination of choice and information rules. Remember, we don't see aggregation and payoff rules here in these instruments, not because we didn't find them, but because they don't exist in the design of the instruments. Here we find remedies, the breadth of accountability, and again, the boundaries. The remedies are what the Ombudsman can do at the end of her own investigation in terms of binding recommendation, specific decisions to comply, and the notification of the recommendations. What we see here is that how these are more than 260 rules, then they start having some presence, right? Some we are picking up around boundary, choice, information, and scope rules, but now we see them also as components that explain the structure of an instrument. And it's not surprising that for the Ombudsman we got the remedies, what the Ombudsman can do, and then for the other. If you remember, for consultation, we have a scope, which is the aims, the participatory dimension of consultation. For impact assessment, remember, the analysis is very component two, very important. And for Freedom of Information Act is the kind of discretionary tests about a request to access information detained by a public body. So far, in terms of description, that the system makes sense. The action situations are there, and they reveal some properties of the instruments that are intuitively the matter. But with this approach, we are much more granular and specific. We see exactly what matters and what variables go or don't go together. Now, being more complicated is the following, which is my final part, and it's about plotting the first two components. The third is not here, but remember, it matters if we. But obviously, graphically, we tried with three. It's a bit more complicated. It can be done. Obviously, you can have a 3D projection, but with this big caveat that the fourth is not there, we can start looking at the plot of the first two components. That for consultation, I put myself there because there is nothing in the. There it goes, nice and small. You're here. Okay, scope, the aims and commitment, and you can see that not many countries are heavy on scope. We have the case of the UK, which is relatively strong also in terms of commitment and in terms of declaring the aims of consultation. Whereas Italy is a case of with Gaia, we said immediately, because we specialized in this sector of consultation when we were checking the data, a bit of communication out of character. There is a flowery language, but no commitment. So that's why Italy loads on high on one component and not the other. We also have countries like you see Denmark and Austria are classic cases of countries that do not use much of the OECD style consultation, which is rigid mandatory procedure. But in the case of Denmark, they use a more flexible system of hearings. Sweden is the same case, and Austria falls into its consultation inside a corporatist type of structure, and therefore it scores 0 in terms of consultation as a rigid, mandatory, prefabricated procedure, open to any type of stakeholders, any citizen, What it gets difficult is to explain the quadrant with 12 cases. These are convergence across systems that do not share historical traits in terms of diffusion of administrative law, do not share much in common in terms of membership of the EU. We find a founding country like Germany, as well as other countries that joined the EU much earlier, like Croatia, much later, Croatia and Estonia. So here is first case where the pieces do not fall into place. But before we say something, let's look at regulatory impact assessment. I won't be longer. This is an interesting case. There are no clear clusters, but something is clustering, but it's not something we would expect to cluster. If you think about administrative tradition or the experience with RIA, UK, Estonia, Romania, they have zero in common. All the projects done on impact assessment in Romania, and we check with our expert in the field, the situation is quite different. So this defies some expectations in terms of the southwest quadrant. This one where we have France, Luxembourg, Finland. We find Belgium, Malta, and Luxembourg where the procedure is barely sketched, right? Malta only has a small business test for new legislation, and that's why Malta probably does not load anything in terms, or almost anything, in terms of analysis. But we also find countries like Finland, where the impact assessment legislation is done, but through more informal cooperation across the departments led by the Ministry of Justice, which is the custodian of good quality legislation. Again, we know why they are together, but they should not be together according to what we learned in comparative politics 101. North-west quadrant, again, difficult to say. The countries are distanced, they are not clustered. And in some cases, like Italy, the explanation of that position is that there is much more in the sector level real guidelines, like the gas and electricity sector in Italy. I'll just move to the next, that maybe something that is more intuitive, the Freedom of Information Act. First, when we extracted these components, we did not find variables that matter in the design according to legal analysis. Examples, provisions to give access to requesters to both information and specific administrative documents, the presence of the so-called public interest override that can be invoked as a final check before an exception is applied, the presence of fees for information access. Ireland was a big saga of the fees. And finally, the sanction imposed for violation of freedom of information legislation. They are there, we scored that. They don't explain much of the variance. Obviously, principal component analysis is about the variables that explain most of the variability. We, however, find some affinities. Obviously, UK, Slovenia, Cyprus are there, but it doesn't go, the explanation, across the lines of, let's say, civil law versus common law. And this, obviously, in administrative law, that's a differentiation that doesn't make much sense. We also find in the northwest quadrant cases from different regions, different times of EU accession, and it's probably, the explanation here is probably that there are affinities that are captured by these granular analysis of all the rules that can be reduced to macro explanation. So these are an important administrative tool, much more important politically than regulatory impact assessment. And well, one thing we can say is probably is not carbon copied by one country to the other. Otherwise, the countries will be much more clustered. On the Ombudsman, we got low degrees again of clustered convergence, but there is something obviously going on in the northeast quadrant, where we have a kind of a accountability mechanism coupled with some harder forms of recommendations. We have 14 countries there. Wave of diffusion of the instrument, we checked, doesn't make sense. Legal traditions, even without opening too many books, you can see it doesn't work. Then we have Poland, Lithuania, Romania, where we have harder remedies with weak accountability mechanisms. And those are interesting, the countries where the Ombudsman is allowed some form of direct sanctioning. And so there is a trade-off between kind of direct enforcement mechanism left to the Ombudsman and weak general accountability. And then we looked a bit at the interrelationship between Ombudsman and courts, and these countries, for reasons that are not explained by macro comparative theories, share these affinities. Okay, let me see if I can bring this to a conclusion. This is a paper that will hopefully allow us to discuss a number of things. Gaia, Claire, and Jonathan, and I don't want to push too many conclusions at this stage on this paper, except by saying that the institutional grammar tool that we used gives us some findings. I remember I didn't put principal component 3 on the graph, so that's another thing we can discuss. But deviate from our conventional categories that intuitively we will use to explain variation across the countries. Why? Well, because many reasons, but one is probably the level of analysis. For macro comparative politics is sufficient to say Austria is corporatist. Okay, it's true, no one. But at this level of analysis, we see many more things that probably are not just there in the shadow of macro explanations, but they demand their own attention and their own analysis. We also see that designs in general are weak, so policymakers have designed these instruments with scant attention to payoff and aggregation rules. There is some originality what we have done, but obviously what is there crying for attention is the analysis of the ecological relationship between the instruments. Consultation and impact assessment seem to go together. In other papers, we looked at the 4 instruments as an ecological independent variable, explaining independent variables. But because we are at the Robert Schuman Center inside the European Governance and Politics Program, we thought that this could be also a nice way of talking between the lenses of the policy design folks like us and the lenses of macro comparative politics, whether there are some bridges to different levels of analysis, components that we haven't examined in sufficient depth, criticisms. We're very, very happy to hear from you at this stage where we are writing these and other 2 or 3 papers at the same time. So many thanks for being so patient and listening to the presentation.
Okay, thank you very much, Claudia, for your presentation. We're now ready to start the discussion with Q&A. As I said, you can use the hand function on Zoom. To do that, you have to go on reactions and then hands appear. Yeah. Or also from the audience in the room. Okay, I see one hand. I'm not sure about the name though, but please go ahead. It's Bishoy.
Yes. Hi. So thank you so much for the presentation. The results are really insightful, which makes me.
Can you just give us a second because we cannot hear you very well. It's very weak. Maybe it's your mic or.
Okay, I'm going to try to come a bit closer here. I hope this is a bit clearer.
It's slightly better, but still quite weak.
Thank you for the presentation. That's very insightful, and it really makes me ask from a more my specialty point of view, policy learning. So I really realize the loadings and the results do not really fall into place, like you say, with the administrative traditions. And it makes me wonder, how much do you put on policy learning and thus transfer and convergence, which definitely does include a time dimension, like you say in the conclusion of the paper. But could these practices, whether learning, transfer, and convergence, explain even a little bit such mismatch between what we traditionally know in terms of administrative traditions and the results of this study? And does that also factor in the perspective on the EU level on these different arrangements, regulatory impact assessments and freedom of information and so on? Do these things have an influence from your point of view?
Daniele, what's the rule? You want to gather questions or one by one?
No, Claudio, please go ahead.
Okay, yeah, and also when they're short, I just go down a bit with my volume because it was up to the maximum to hear Bishoy. Bishoy has worked on policy learning, as a nice paper on COVID and policy learning. I see your question, and I am myself interested with my co-authors in policy learning. We need other data on longitudinally sensitive data that look at a year of adoption, type of changes in the four instruments. Remember that consultation impact assessment did not exist in the EU practically before 1995. So it's a nice story to tell also for Freedom of Information Act. Ombudsman is a different story in terms of diffusion. And then linking to the second part of the question, which is about the presence of the European Union providing master template or guidance on this. This is not obviously part of the binding laws and regulations, so-called acquis communautaire. Sometimes I heard EU negotiators talking about the political acquis in relation to this, and also its OECD good practice, 1995 Council recommendations, OECD 2012, principle of high quality governance. I would say that the EU has not be sufficiently strong, or maybe has to impose a template, and sometimes it's actually the opposite. It's member states that have pressed the EU on their own favor, kind of uploading their preferences to the EU level. And what the data say, just to be very humble here, humility is a good virtue in political science. The data are a photograph, and they say this is what it is now. And then whether it's because there is uploading, downloading, those are my intuitions, but we need another segment of the project with other data that contain time to answer that. And then comparing with my co-authors, we are doing a paper comparing the overall guidance country by country, and then seeing whether Malta is copied from the EU or not, or whether you can do these things, but not with this data. But thank you. Those are two big topics that we are considering.
Gaia, yes, please.
Yeah, thanks. I just had one point, but Claudius clearly answered the question about convergence and I would say hypothesis testing maybe. But I just want to say that this particular manuscript is really about, I mean, the results that we have shown is the outcome of a theory-driven exploration of the variation. So we stop at a description of the variation that we observe. So it's really not, it's like a step before theory testing. So, but of course there is a lot of space, I guess, to start testing this kind of hypothesis. But this is our next manuscript, I would say. Thanks.
Diane Stone.
Hi, thank you, Claudio. I must admit my interest was sparked right at the end when you mentioned an area of future research would be looking at the ecological interrelationships of instruments. And whenever I hear the word ecological in social sciences, I tend to think of Andrew Abbott's framework of linked ecologies. Now, I'm fairly sure that's not what you're thinking of here, but I'd be really interested if you could elaborate on what you mean by the ecological relationships. Is this an ecological relationship in terms of the process of policy design? Is it about an institutional ecology or some other kind of ecology? I'm really interested to sort of know where that kind of angle of research would go forward.
Thank you. I'm answering the questions. I wonder if Jonathan Kankaji, no, okay, otherwise it's going to be Guy and me. Okay, yeah, it's a great question. Every project has limitations, right? The limitation of this project is that when we think about ecological relationships, we think about the following. If you strip down what we said in this paper to the barest essentials, you can say that all these procedures are combinations of enfranchised interests and obligations imposed on regulators and government departments. The ecological question is, how does the overall set of rights and obligations create effects on an outcome? So when we think about ecology, say, okay, all this stuff constrains rulemaking by conferring rights and by imposing obligations, then what is the effect on citizens' perceptions of X? What is the effect on doing business? So in the other papers that we have, we take an outcome like quality of the business environment, and then we look at the combination of conditions that together are either sufficient or necessary for the outcome to occur, which means is more about set theoretic thinking, and the ecology reveals itself as a sufficient condition configurationally for the outcome we observe. Is not incompatible with what Andrew Abbott says, but definitely not the same thing. Is another way of looking at ecology. Yeah, still legitimate, and yeah, great question. We will think about Abbott then.
Okay, thank you, Claudio. I've now Bernard Höckman and then Adrienne Letier. Bernard, please.
Hi. Yeah, so Claudio, I think you already maybe answered this just now, but one of the things that struck me is, this is all very interesting, but so what? So, in terms of outcomes, so to what extent are we, or are you guys, and I guess that is part of the project, so it doesn't really come out of the paper, but ultimately, I'd be interested, of course, in, what do we take away from this type of analysis in terms of things that are actionable, in terms of improving outcomes that actually matter? either in terms of stated objectives or in terms of what, you know, citizens of countries care about. But I guess that is part of the project. So that was one of my, that's basically the thought I had as you were talking. Thanks.
So Bernard, I'll follow up. We take, you can take these components, right? Like imagine the first component, or you can aggregate the first two as conditions for an outcome to occur. And in another paper, we're doing exactly this. We calibrate the components that explain most of the variance of an instrument, and we set theoretic methods. We look at their effect on the quality of the business environment. So these, I know at each seminar you can present only one paper, but in the other paper, this one is the simple paper that gives us the data to do the other things that we want to do. These are different work on the outcomes. So we look at perceptions of corruption, and that's a paper that appeared in Journal of European Public Policy at the end of last year. And then we have one on the quality of the business environment. And we're struggling to produce one on trust, because probably there is some other element of the causation that we have to theorize better. So we are going in the direction of qualitative comparative analysis with Claudius Waggemann as our additional co-author for the papers with the outcomes.
Okay, Adrienne.
Thank you very much for these very interesting data which you present, which are really daunting in terms of the wealth of data. My question is, going back to theory and explanations of the patterns you find. You did mention two possible explanations within each instrument if you looked at the different kind of results as they were kind of presented in your presentation. But do you already have, because your colleague then mentioned you're going to theorize your findings at one point. So you start from the empirical findings and then inductively look at what the regularities are or what patterns are. And then if you could say a little bit more about the kind of elements of theory in the patterns. You did mention some examples, but it's not that it's kind of a midterm theory as yet. So have you some steps, some conjectures which are most promising in explaining just the distribution or the position of the various countries within one instrument? If you could say a little bit more about that.
Yes, as Gaia interrupting, but what you were saying before, Gaia, is that, which is true, obviously, is that the theory in this paper is the theory that leads us to measurement. No? This Ostrom stuff and is not explicitly theoretical in the sense of testing hypotheses, which is okay. I think, yeah, if you do 7 papers, one can be like this one and creates the data sets can be used by, you can plot 3 components, 2 components. Other people can use it, you can match against the OECD data. But one thing that Adrienne is correct, and thank you for this, is that you must say something about the patterns you find, right? And we cannot just say those are the data. And what we said, I'm just looking back at my notes. Well, in terms of the patterns, there is this striking miss of the at the design stage of payoff and aggregation rules that gives weak traction to these instruments. We will find some champions of informality, Denmark, Sweden, and to some extent, in some cases, Finland, that practically deviate from all these regulation of rulemaking, which is very 12 weeks for consultation, 6 types of analysis for RIA, communication on the portal. All this is, at least for the first 2 instruments, is less important. So they tend to be out of, they're not seeking rules, let's put it this way, or they have different rules regarding the hearings and corporatist agreement, and that's what puts them together. We also have the countries that are like Cyprus and Italy, or Romania in one case, that produce communication out of character. So loads of flowery language, but not a lot of commitment, not a lot of analysis. And then if you think about, I have a note on the Ombudsman, there's something to explore in the part is that in the case where the Ombudsman is strong in terms of remedies, you'll find that there is a kind of attempt to make up for courts that tend to be weak in transition to democracy or being weakened after the transition to democracy. So it's the Ombudsman as a surrogate of a weak judicial system, but knowing that the Ombudsman is by itself not a body that operates like a court. So you got some interpretation. You can see some cluster, and you can see where, in the 4 graphs, there are graphs where you have something that could almost call a cluster, and graphs where the situation is 0. There is no European story there. They're all in different places. In others, there is what Tanya Berzer said, a bit of clustered Europeanization. And I think in the conclusions, these elements should come out in a stronger way. So thank you, Adrian, for this observation. But we can say something, hopefully, on this.
Okay, thank you. Are there any other questions or comments? I see one question in the chat.
There's Philip.
So I'm going to read out the question in the chat and then go to Philip. So the question in the chat is, enfranchising the public that are not only constraining for the state, but enable it by providing added information and input legitimacy to regulatory rulemaking. Positive sum, i.e. win-win situation. I don't know if this question is clear enough.
Yeah, I'm sorry for posing it in a written form. The internet is terrible where I'm looking you at. I was just wondering.
We can hear you fine now. Maybe you can just ask your question.
Yeah, sure. Thanks for a very, very interesting analysis. And I think it really has an added value in comparison to the macro analysis as spelled out by the authors. Well, my question regards the very introduction of the paper when you justified the analysis of these 4 instruments, and I was wondering if it could be strengthened why these 4 and not some others. And in terms of concept formation further, these instruments are defined as instruments which simultaneously enfranchise the public and constrain the regulatory government. So I thought this is quite a liberal, let's say, perspective, and was wondering whether we could also think of instruments which enable the government and enfranchise the public, such as, which is also the aim and intention of democratic innovation participatory tools. So I don't know if the question is clear.
I think I understand the question, and Gaia intervene before, after me, as you see fit. But the question is whether there is Protego Plus, right? Our project is called Protego. Can you extend this approach? Petar is asking. We can extend it in 2 ways. One is that I could take a procedure for participatory budgeting or for participation, I see Petar says yes, I love it. Okay, yes. See, okay, it's an action situation called participatory budgeting. What are the position rules? What are the boundary rules? And then maybe collect these data and add it to other data. So, okay, we have an impact assessment, but we also have deliberative participatory instruments. They too are action situations, maybe not for the preparation of a new regulation of chemicals, but why not? Maybe it's about the incinerators in a city. So the answer to that extension is yes, because as Gaia said before, at least in this paper, the theories and how you see these procedures, and a procedure with positions, boundaries, aggregation, scope is like any other. The second one, I know what you're pushing us a bit more on the political side of things and say, but can the governments then not benefit from these? So, okay, they're saddled with these requirements, but then open government, transparent government, participatory government, analytical government with impact assessment, government that mitigates maladministration with the Ombudsman, that could be good for trust, which goes back to the paper that we're trying to write on whether this bundle of liabilities and rights, obligations on governments and rights for those who are consulted or can request documents, has some positive effects on the quality of governance as measured, for example, by support for institutions or trust, is a thing that we should consider, that we are considering. We don't have any data yet. Is the analysis we're carrying out at the moment, but in that case, you can say win-win, because the government earns by doing things that are trustworthy. The government earns trust. Sorry, I went too long. Gaia, I'll leave you the next, unless you have a few words on this as well. Sorry.
Philip Genschel.
Yes, thank you very much for this very interesting presentation. So I just heard the presentation. I've not read the paper, so my comment may be besides the point. But what's interesting about the 4 scatter plots is that they really show no obvious pattern. So all expectations you may have for, I don't know, varieties of capitalisms, world of welfare, civil versus common law, north versus south versus east, don't give you much leverage to explain these patterns. So my question is, may that simply indicate that your 4 instruments are not very important, so that the stakeholders of the regimes do not really care a lot how these instruments are designed, and therefore you have a strong stochastic element in how they are designed. So how do you know how important these instruments are, in fact?
I'll pass to Gaia for the answer.
Okay, I'll start, then Claudio maybe can add something. That's a very interesting question. I don't think this is about these instruments not being important. I think that our approach, so we selected the IGT approach, we showed them our empirical results, and then we reduce our complexity. We compare at a level of granularity. So we go really into micro aspects. And this is just, our findings are just at a different level of comparison. So that's why we don't find correlations and typical clusters of comparative politics, but we find something different. So it's not, I would say that, less or more importance. It's about really a different level of analysis. But Claudio, if you want to add something on that.
Thank you, Philip. This is original, and I will ask for your help on how to build on the assumption that if stakeholder does not interest, then procedures are designed in different ways. Because I thought, well, actually, stakeholders care a lot in every country. They design the instruments as they see fit, but are the stakeholders designing these instruments, or are the government? But it's interesting anyway. What I want to say is that, at least the way we see this data today, we can always change our priors, but the way we see it is that the message that comes from the low clustering is you have to tell the story at the level of these instruments or even these countries. And when we looked inside Cyprus and Romania, what happened with the European Union consultants and World Bank, and then you understand why Romania is there. So at the moment, we are very much persuaded by it. That's the level of analysis where you see things that it may be true that Italy is a polarized pluralism, or it doesn't show in this kind of stuff. It could be because there are communities of lawyers that design administrative law, which makes sense. It could be, as you said, Philip, that some instruments are generally atrophic, so isomorphic, they copy some guidelines, but who cares? But then there will be all carbon copied from the World Bank consults, because we checked and the World Bank and the EU always say a consultation, 12 weeks, So, or it could be a story that I heard initially from Adrienne Héritier 20 years ago of customization of Europe, or you read Europe from the bottom up, and these instruments serve local constituencies, epistemic communities of lawyers, the system of courts in transition to democracy. I remember Adrienne wrote on road haulers and truck drivers and explained, Italy, you only understand if you know the story of the concentration of ownership in this sector, and then you cannot say Italy is X. It's a bit of a drop the box exercise, whether you can drop them into macro categories or you can take that level of analysis and carry forward. But your intuition probably works more for consultation and RIA than for freedom of information and ombudsman. But I come and visit you when you have time to have more wisdom and enlightenment on this, which is probably, I would not say today is the truth, but may explain some of the findings.
Okay, yes, thanks, Claudio. Philip, I saw you nodding, and now you seem, I don't know if you have a rejoinder.
No,
you are satisfied.
I think Claudio has a very good point. If it was indeed true that these instruments were not important, then you would expect extreme clustering. They should all be in one place because, as Claudio said, states simply copy carbon a blueprint from some IO. And this is clearly not what the scatter plots show, and this shows that there is something to explain. Yes, thank you.
Okay. I must admit, the answer you gave now, Claudio, went a bit in the direction of a question I had, and you were referring yourself to links with comparative politics, and Gaia also now spoke of the typical clusters of comparative politics. And I was wondering, in your narrative, what the role would be for the typical actors of comparative politics and the typical processes, political parties or types of coalitions. Is there any role for variation, ideological variation, left, right, the influence of interest groups? Do these actors, these processes, these factors play any role in the variation that you observe?
And then, if you look at testing a blunt hypothesis for what you can do with only 28 cases, maybe with time you would have obviously another source of variation, which is very interesting, and that's the work done on waves of diffusion of these instruments, like the different ways of diffusion of the Freedom of Information Act, or the waves of diffusion of impact assessment. I think you would find that some of these instruments are sheltered from party competition, not by pressure groups and not by epistemic communities of administrative lawyers that serve in key position in Conseil d'Etat, in government, in the key departments of justice, very important in countries like Finland, Romania, historically, obviously, France, Italy, etc. If you go outside the EU, in Switzerland, it would be SECO, the kind of cabinet office at the federal level. So the parties, ideologies, it doesn't look like there is a neoliberal deregulation across the four. There is a bit of heterogeneity. Maybe there is a bit of new public management ideology in consultation and impact assessment, rational design, open up, is going to be fine, everything is win-win, and maybe less in freedom of information. Remember Tony Blair said, I regret having introduced the Freedom of Information Act. But again, talking about parties, for Blair, the introduction of the FOIA in 2001 was a signal of what new labor meant to be with open government, etc. They are not, except from freedom of information, where you find advocacy coalitions for freedom of information. The other three, especially constitutional impact assessment, are a bit for the specialists, so more epistemic communities, lawyers, administrative lawyers, constitutional lawyers, and interest groups. They like this stuff. Strange pressure groups like journalists, obviously, they're a big constituency. NGOs are very active in one instrument, at least, the Freedom of Information Act. So yeah, I would say case by case, you can tell a story, and I'm not so sure about, maybe it varies, yeah, especially for ideology, it varies across the instruments, not across the countries.
There is a follow-up question from Adrienne. Adrienne?
On mute, can you hear me now?
Yes, yeah. You're muted again. You have to unmute yourself.
Now, can you hear me
Yes.
now? Okay.
Yes.
So as regards access to information, freedom of information, I remember from our research in Europeanization of environmental policy, also 20 years ago, that we found Access to Information Act very politicized. A lot of opposition from industry, supported by the Conservative Party, for instance, in the UK. So I could imagine that you would find there kind of variables which then explain why states react in a particular way. If indeed, you know, this Freedom of Information Act is similar to the access to information on production processes on the part of industry regarding in environmental policy making, that's kind of a question. And the second point is when you talk about, we may have a look at diffusion theory and what is being claimed and how they spread across and how they're applied across these 28 countries. But then you know, of course, that diffusion theory in a way has to say why it plays out in a particular way in each country, right? And then you're back to kind of having explanatory factors or at the country level or at a higher meso level.
Yeah, it's true. In our data on access of freedom of information, we have a portion that is just the Aarhus Convention, right? And that's what defines this domain of environmental sustainability policies, where the Aarhus Convention goes along the story that Adrian rehearsed a minute ago. Just to say that the data also have freedom of information as a more general story. Some countries only have Aarhus and as predominant driver of freedom of information. Others have a Freedom of Information Act, which is recent, and therefore it's very difficult to theorize the effects of, you shouldn't actually, of instruments introduced in 2016 and 17, and it goes back this to time and diffusion. There are different stories about the diffusion of impact assessment. This book by De Francesco on the OECD role, and less so the European role, and different stories about the diffusion of Freedom of Information Act. So on that, the instruments, we are abandoning the framework of IGT, of Ostrom, and maybe we are adding time, we're adding history, we're adding context, and maybe becomes more a story instrument by instrument, and within Freedom of Information, Aarhus and the rest, which means there are some more papers we can write on these, and certainly there. I'm unhappy that in this paper there is no time variable to control for. We have it, and at this point for this paper, I don't know what it would do, but certainly in a diffusion paper would say much. And when we measure the effect of the instruments on the outcome, obviously time, something silly, or basically longevity of the instrument matters. Freedom of information in some countries then pooled by different political parties across the years as well. So you can see parties in government being less than happy about the existence of a Freedom of Information Act.
I'm not sure there are more questions. If not, I will give to Gaia maybe for some final remarks, and then Claudia.
So just to conclude, I'm thankful for all the comments, and as a co-author, I'm very happy that this paper, as you've seen it, a descriptive analysis of meta-regulatory instruments somehow paved the way for further explanatory comparative analysis that maybe go in a different direction, also in terms of dimensions of analysis of classical comparative politics clusters, for instance. So as we said, we are not engaging yet in hypothesis testing, but our next papers, or we also have a paper, as Claudia mentioned, in JEP that just came out in 2020 with an outcome, for instance. So we have different analysis that we made, but I will, keep engaged to see where our instruments are going in the future, maybe in a Protego Plus, as we also said, Claudio.
Yes, Peter is on board. Well, no, many thanks for this. Just to say that we believe that we can publish this paper, obviously, because it's a good paper for those who do the IGT, because IGT has not been used on this number of legal procedures. Usually it's used on a single legislation on tobacco in Mexico is one example we found, and not on 28 countries. So we're bringing IGT from the forensic analysis of forestry in Wyoming to something that is bigger, like the European context. There is a story that I like about the level of analysis and the bridges between policy analysis and comparative politics. So that's what is not just a paper to write other papers. And then there is the best paper we have to present the data set and show how it can be used. Obviously, when we publish this, we publish also the time variable for those who do diffusion studies, including ourselves, that we are interested in diffusion studies. But I hope, on the one hand, I think the message came across about what the paper is. It's not just the data, it's something. We had so many useful leads for further research from Andrew Abbott to win-win situations to diffusion venues and patterns. So it's thank you for your generosity. It's great. Thank you.
Thank you, Claudio. We are now approaching 2 p.m. and the seminar comes to an end. Thank you very much. Well, Claudio and Gaia, but also Claire and Jonathan. It has been a true pleasure to have you. Thanks for presenting your data set and the first results that you get. Good luck with the next papers and with the project. And thank you everyone in the audience for attending and for your inputs. We'll reconvene in 2 weeks' time with another research seminar and a talk by Stefan Telle and Claudia Badulescu on differentiated integration. And hopefully I will see many of you in 2 weeks' time for another interesting session and hopefully with a seminar in presence again. Thank you and have a good afternoon, everyone.
You too. Thank you, Daniela, for convening. Bye-bye.
Thank you. Bye-bye.